If you're over 60, you've probably heard this message more than once. You're getting older, maybe it's time to slow down, maybe it's time to give up certain responsibilities. That idea gets reinforced in subtle ways, by family members who mean well, by doctors who are focused on liability, by media narratives that treat aging as decline, and sometimes even by local officials who blur the line between concern and authority. But here's what almost never gets explained clearly. Turning 60, 70, or even 80 does not erase your gun rights. There is no age at which the Constitution quietly stops applying to you. Rights do not expire with birthdays. Today, we're going to walk through firearm rights seniors still have under U.S. law, rights that are often misunderstood, overlooked, or quietly discouraged, and why understanding them matters now more than ever. This is not legal advice, but it is grounded in how the law actually functions. Let's start with the most basic and most widely misunderstood fact. There is no federal law that disqualifies someone from owning firearms simply because they reach a certain age. There is no expiration date on lawful ownership. There is no automatic cutoff at retirement age. Federal firearm prohibitions are triggered only by specific legal conditions, such as felony convictions, certain domestic violence restraining orders, or formal mental health adjudications made by a court. Age is not one of those conditions. Yet many seniors are pressured into believing that ownership becomes illegal, dangerous, or irresponsible simply because they're older. That belief is not supported by law, but it is spreading quietly, often through social pressure rather than statutes. Another core protection that does not disappear with age is due process. Your firearms cannot be lawfully taken away without proper legal procedures, regardless of how old you are. That process generally includes notice, a court order, and an opportunity to challenge the action. Being described as elderly, confused, or at risk does not override constitutional safeguards. Concern does not equal authority. Even well-intentioned actions can cross legal lines if due process is ignored. Courts have repeatedly affirmed that constitutional rights apply equally to seniors, and that age alone is not justification for bypassing legal protections. Medical conditions are one of the most common areas where confusion and fear lead to unnecessary surrender of rights. Having arthritis, diabetes, Parkinson's disease, limited mobility, hearing loss, or even early memory concerns does not automatically disqualify someone from owning firearms. Under federal law, firearm rights are affected only when a court formally adjudicates someone as mentally incompetent or orders involuntary commitment to a mental institution. A doctor's opinion, a medical note, or a family concern does not meet that legal threshold on its own. Medical assessments are not legal rulings. When those two things get blurred together, people often give up rights they still legally possess. Something that is almost never discussed publicly is the issue of access and accommodation. Seniors may still be entitled to reasonable accommodations in firearms training, testing, and licensing processes. Under federal disability law, including the Americans with Disabilities Act, accommodations can include modified shooting positions, adaptive equipment, additional time for written exams, mobility considerations, or alternative formats where appropriate. The right to keep and bear arms is not just theoretical, it includes the ability to exercise that right in practice. Aging does not mean exclusion, and it does not mean automatic disqualification from participation. Carrying firearms follows the same legal logic. In most states, age alone does not invalidate a concealed carry permit, nor does it disqualify someone from constitutional carry where applicable. If you meet the legal standards, your permit remains valid. Renewal requirements must be applied equally, without arbitrary age-based hurdles. Singling out seniors for extra scrutiny or denial purely because of age can raise serious equal protection concerns. The law does not recognize a separate, lesser class of constitutional rights for older Americans. Self-defense is another area where seniors are often misunderstood or underestimated. Castle Doctrine and Stand Your Ground laws, where they apply, do not include age limits. In fact, courts often recognize that seniors may be more physically vulnerable, which can strengthen a lawful self-defense claim when force is justified. The right to defend your life, your home, and your personal safety does not retire when you do. If anything, the legal system often acknowledges that older individuals may have fewer options to escape or physically resist threats. Firearm inheritance and estate planning are also widely misunderstood. Firearms do not automatically become illegal simply because someone is aging or passes away. Lawful transfers to heirs are protected under federal and state law when done correctly. This includes inheritance through wills, trusts, or estate processes that comply with applicable regulations. Estate planning is not just about property, it's about preserving lawful ownership and preventing unnecessary confiscation or destruction of firearms due to confusion. Surrendering firearms out of fear or misinformation is not legally required. There are also persistent myths that circulate among older Americans that have no legal basis. One of them is the idea that jury service exemptions, declining jury duty due to age, or changes in civic status somehow affect firearm eligibility. They do not. Jury service and firearm ownership are governed by entirely separate legal frameworks. Confusing the two has caused many people to give up rights they never lost, simply because no one explained the difference. At the constitutional level, the Second Amendment itself contains no age clause. There is no retirement provision written into it. There is no health-based expiration date. Recent Supreme Court decisions have reinforced that the right to keep and bear arms is an individual right deeply rooted in American history and tradition. That protection applies to law-abiding adults, including seniors. Courts do not treat age as a reason to erase enumerated rights. Finally, and this is one of the most important points to understand, voluntary surrender is not mandatory. No one is legally required to give up firearms simply because family members are uncomfortable, a caregiver suggests it, or a doctor raises concerns without court involvement. Voluntary surrender is exactly that. Voluntary. It is a personal choice, not a legal obligation. Aging does not erase constitutional rights, but misinformation can quietly convince people that it does. Knowing where the law actually draws the line is the first step in protecting your freedom and making informed decisions. This is To a Freedom, focused on facts, law, and constitutional reality.